Good afternoon, everybody, and welcome to this webinar live from the Carrier Law Studios. I'm Lee Dillard, and next to me is Heather Green. We work in the Trust Administration Department of Carrier Law, and today we are going to talk about separate share trusts. Before we get started, though, I've got a couple of housekeeping details to go over. First, this webinar is being recorded and will be available on our website soon. Second, as the webinar proceeds, I'm sure you'll have questions. Please put these questions in the question and answer feature, and we'll answer all of them at the end of the webinar. Finally, the subjects we will be covering today can be very legally complicated, and we are going to be covering this material in a very broad brush manner in an effort to make it understandable. Just know that every fact situation, especially your particular fact situation, can be different. As a result, you always need to consult an attorney, hopefully one of our Carrier Law attorneys, when you are doing an estate plan or trust administration. Now, let's get started. A separate share trust can be a powerful financial planning tool to put things in context and hopefully make what could be a very dry subject somewhat lively and entertaining. We're going to start this webinar off by introducing you to a family situation to show you when, where, and how the separate share trust comes into play. Heather, can you introduce our family to our audience, please?
I sure can. I'd like you to meet siblings, son and daughter. In our scenario, they could be anywhere in age from their 20s to their 50s. Son and daughter were raised by mom and dad in the Grand Rapids area, and son and daughter remained in the Grand Rapids area after they left home. Son and daughter remained close to mom and dad, but like a lot of families, mom and dad really never discussed their finances with son or daughter. Mom and dad also never really discussed anything about their estate plan with son and daughter, except to say that about 5 years ago, they came to Carrier Law and they got their estate plan done. Dad passed away 3 years ago. Mom continued to live in the family home that son and daughter grew up in, and son and daughter visited her regularly. Like I said, they were a close family. However, mom still never really discussed finances with son or daughter, and son and daughter didn't think it was appropriate to ask. Mom did, however, tell son and daughter that when something happened to her, they were to find her big blue Carrier Law estate planning binder and to call Carrier Law. A few weeks ago, mom passed away after a short illness. After the funeral and some time to grieve, son and daughter met at mom's house. They started looking through her things and they found some financial documents, and they found that big blue Carrier Law binder that she had mentioned. Lee, would you like to share with our audience what son and daughter found in this big blue binder?
Absolutely. The binder contained a bunch of documents, including a will, a healthcare power of attorney, a financial power of attorney, and not one, but two trusts, something called the Family Trust and another trust called the Family Protection Trust. Son and daughter also found some statements, including a statement for a checking and savings account containing about $20,000, a statement for an investment account with Edward Jones worth about $80,000, and also the deed to the family home, which they believed was worth about $100,000. They really weren't sure what they were reading, but it kind of looked like to them like all of these assets were in the name of one of the trusts rather than just in mom and dad's name. But because they really weren't sure what was going on, they called Carrier Law and they made an appointment with Heather and I to talk about mom and dad's estate plan and, most importantly, what it meant for son and daughter. Before the meeting, Heather and I, as we always do, reviewed mom and dad's estate planning documents, specifically the trust documents, and also the investment and bank statements and the deeds. And we determined that all of mom and dad's assets, the bank account, the Edward Jones account, and the house were indeed trust assets owned by mom and dad's trust. We also determined that the trust stated that mom and dad wanted these trust assets to be split equally between son and daughter. Most importantly for our webinar today, we determined that mom and dad's protection trust stated that son and daughter would take their equal share of the trust assets in what we call the separate share trust. This is key. A person cannot just create their own separate share trust because they feel like it or want to. Rather, a separate share trust is created in another trust. Now, Heather, would you like to take it from here?
Absolutely. So this is where the separate share trust comes into play with the carrier law estate plan. When someone passes away who had created a trust with carrier law, it is the living beneficiaries of that trust who are entitled to take their share of the trust assets, also known as their inheritance, in a separate share trust. In our family's case, Mom and Dad's protection trust stated that a separate share trust could be created for each son and daughter. A separate share trust is designed to protect a beneficiary's inheritance. For that reason, we sometimes refer to it as an inheritance trust. The protection over the inheritance is in place from the day the trust is established. This is different than the trust that we use for our regular estate planning. For example, as we previously mentioned, during their lifetimes, Mom and Dad established what was called a protection trust as part of their estate plan. This protection trust was intended to provide Mom and Dad with asset protection in case one of them ever needed to go into a nursing home and get on Medicaid. However, the asset protection afforded by one of our protection trusts does not start until the assets have been in that protection trust for 5 years. And we call this the 5-year clock. Now, the 5-year clock does not apply to the assets in a separate share trust. Rather, once the separate share trust is set up and the beneficiary's share of the trust assets are put into it, the asset protection afforded by the separate share trust is in place from day one.
So Heather, what does the separate share trust protect the inheritance from?
The assets in the separate share trust are protected in case the beneficiary is ever sued, if the beneficiary gets divorced, or, and this is most important for carrier law since we are a Medicaid planning firm, the assets in a separate share trust are considered off the table for Medicaid purposes, which means that they won't have to be spent down if the beneficiary needs to go into long-term care in a nursing home on Medicaid.
Okay, that's a lot of information. So let's recap. Mom and Dad did their estate plan with carrier law, and they have now both passed away. The trust part of Mom and Dad's estate plan provides that son and daughter each get half of the trust assets, which are the bank and investment accounts in the house. Mom and Dad's trust, more importantly, also provides that son and daughter can take their share of these assets, their inheritance, in a separate share trust. Finally, when the assets are in the separate share trust, they will be protected in case son or daughter ever gets sued, divorced, or if they ever need to get qualified for Medicaid. Does that about cover it?
Yes, it does.
So I guess the next question is, how do you set up a separate share trust?
The first step in setting up a separate share trust is for the beneficiary to select a trustworthy co-trustee.
Well, what's a co-trustee and why do I have to have a co-trustee?
Well, a trustee is a person who manages the assets in a trust. Some trusts have just one trustee, but a lot of trusts have 2 trustees. When a trust has 2 trustees, we refer to them as co-trustees. For example, Mom and Dad were the co-trustees of their protection trust while they were alive. A separate share trust also needs 2 co-trustees. The beneficiary will be one of the co-trustees, and then they pick someone else to be a co-trustee with them. The co-trustee is needed so that the beneficiary does not have sole control over the assets. If the beneficiary had sole control over the assets, then the assets wouldn't have the protections provided by the separate share trust.
And what are those protections again?
The separate share trust protects a beneficiary's inheritance in the event of divorce, getting sued, or needing to go into long-term care in a nursing home.
So if there's no co-trustee, then there's no protection?
Correct.
And if there is a co-trustee, then there is protection.
That's right.
So since you have to have a co-trustee to enjoy the asset protection of the separate share trust, then you probably want to be trustworthy, right?
Exactly.
Who do most beneficiaries pick as a co-trustee?
Most beneficiaries pick someone close to them, like a spouse or a sibling or a child, but it could be anybody over the age of 18.
Okay, to recap, a separate share trust needs 2 co-trustees to manage the trust assets. One of the co-trustees will be the beneficiary, and then the other co-trustee will be someone picked by the beneficiary who is trustworthy. Now, what else is needed to set up a separate share trust?
There are 4 basic documents needed to create a separate share trust: an acceptance of trust, a certificate of trust, a line of credit, and an SS4 application, which we use to apply for a tax identification number for the trust. So the first document is the acceptance of trust, and this is the document that makes the beneficiary and their selected person officially co-trustees. Each co-trustee will sign their own acceptance of trust. The certificate of trust is each co-trustee's driver's license. Just like a driver's license gives a person the authority or right to drive a vehicle, the certificate of trust gives each co-trustee the authority to act on behalf of the separate share trust. Each co-trustee will sign their own certificate of trust. The line of credit document allows the beneficiary to borrow from his or her separate share trust. This is something that Lee will talk about a little more in just a little bit, but each co-trustee will sign this line of credit document. Finally, because a separate share trust is its own separate legal entity, just like a corporation, a separate share trust has to get its own tax identification number. Just one of the co-trustees needs to sign the application to get this number. So that's how the separate share trust is created. And now Lee's going to talk about how a separate share trust can be managed.
Thank you. So to talk about how a separate share trust can be managed, I'm going to go back and pick up with son and daughter at the point right after they learned in their meeting with Heather and I that they were entitled to take their share of mom and dad's trust assets in their own separate share trust. We then went into that period of trust administration called asset liquidation. So this meant for son and daughter that the house was sold for $100,000, the Edward Jones $80,000 investment account was cashed out, and the bank account with the $20,000 in it was closed. All of this money, which now totaled $200,000, was deposited into a new bank account in the name of Mom and Dad's Family Protection Trust. Because all of the assets were liquidated, it was now time for final distributions from Mom and Dad's trust and to set up a separate share trust for son and daughter. So to set up their separate share trust, son and daughter's first task was to pick their co-trustee. Daughter had never gotten married, so she chose a very close and trusted friend to be her co-trustee. Son, who was married, chose his wife as his co-trustee. Daughter and son and their co-trustees met with Heather and I, and everyone signed the needed documents, which, if you recall, are the acceptances of trust, the certificates of trust, the line of credit, and the application for the tax identification number. Heather and I then obtained that tax identification number for each trust. Once this was done, daughters and sons' separate share trusts were officially set up. Now I'm going to talk about what daughter did with her separate share trust. She and her co-trustee opened a bank account named the Daughter Separate Share Trust, running under the separate share trust new tax identification number at her local bank. She then deposited the distribution check she received from Mom and Dad's trust for her 50% share of the trust assets, which was, if you recall, $100,000, into this new account. Daughter then didn't do anything with this money for a couple of years. However, in year 3, she decided she wanted a new car. So she went to a local dealership and picked out a new vehicle for $40,000. Her co-trustee wrote a check to the dealership for $40,000. Then there was one other important thing her co-trustee needed to do. Remember that Heather talked about how the beneficiary can borrow from their separate share trust using the line of credit? Well, what happened here was that daughter borrowed $40,000 from her separate share trust to buy her new vehicle. So her co-trustee made an entry on the schedule for the separate share trust line of credit that on this particular date, daughter borrowed $40,000 from her separate share trust. Daughter then waited another couple years, and then in year 5, she decided she wanted to do various improvements to her home. She got estimates for various repairs and upgrades totaling $40,000. Then her co-trustee wrote a check for $40,000 to the contractor that was hired to do the improvements. Her co-trustee also noted on the separate share trust line of credit schedule that on this particular date and time, daughter had borrowed another $40,000 from her separate share trust. Daughter then waited a couple more years, and then in year 7, she decided she wanted to take a vacation. So she booked an Alaskan cruise. Her co-trustee wrote daughter a check for the $20,000 remaining in daughter's separate share trust account to pay the cruise line. Guess what else her co-trustee did? You got it. Her co-trustee noted on the schedule for the separate share trust line of credit that on this particular date and time, daughter had borrowed the final $20,000 remaining in her separate share trust. So with no more money left in her separate share trust bank account, you might think, well, that was fun while it lasted, and that's the end of the story. However, it's not. In year 10, daughter unfortunately and unexpectedly got sick. She remained mentally competent to make decisions for herself, but she was no longer able to physically live at home and take care of herself. For a variety of reasons, daughter decided that her best option was to be admitted to a nursing home where she could receive the care she needed. As a result, daughter, with the assistance of her co-trustee, who was also her financial power of attorney, checked with carrier law about getting daughter qualified for Medicaid. Daughter learned that in order to get qualified for Medicaid, she could have no more than $2,000 in cash, and that she would be expected to spend any money she had in excess of $2,000 on nursing home care herself before she could get qualified for Medicaid. It so happened at this time that daughter had $102,000 in her own personal savings account. In a typical case, daughter would have had to spend down $100,000 of this money on her nursing home care before she could get qualified for Medicaid. However, this is where the separate share trust line of credit comes into play. Remember that daughter had borrowed $100,000 from her separate share trust over the years? Because she had borrowed it, daughter could now pay it back. So $100,000 was taken out of daughter's savings account and deposited into her separate share trust account, thus repaying daughter's loans. This left daughter with $2,000 in her own savings account, which meant that she did not need to spend down any further cash to get qualified for Medicaid. Now, this is a very simple example, and there are many other factors that come into play in getting qualified for Medicaid. However, I hope this example shows you what a powerful financial tool a separate share trust with its line of credit can be. So now we're going to give Heather a turn. Would you like to take it from here and talk about what Son did with his inheritance?
Yes. So if you recall, Son named his wife as his co-trustee, and he and co-trustee wife opened an account with Edward Jones named the Son Separate Share Trust. They funded this account with Son's 50% share of mom and dad's trust assets, which, if you remember, was $100,000. This account ran under the same tax ID number that was obtained for Son's Separate Share Trust. Son did not do anything with this money for several years. He just let it sit in this investment account and grow. By year 3, the initial investment of $100,000 had grown to $120,000. You might ask, does this additional $20,000 of gain get the same protections afforded by a separate share trust as the original $100,000? And the answer is yes, all of it is protected by the separate share trust. In year 5, Son then decided that he wanted to buy a cottage up north. Co-trustee wife wrote the seller of the cottage a check for $120,000 from the Son's separate share trust investment account. And the seller signed a deed conveying the title to the cottage, not to Son and his wife, but rather to Son's separate share trust. Son and his wife enjoyed the cottage for several years. However, in year 8, Son also unfortunately and unexpectedly got sick, to the point that wife could no longer care for him at home. And she made the heartbreaking decision that the best thing for Son was to get him qualified for Medicaid so that he could be admitted to a nursing home where he could get the care that he needed. Wife learned that in order to get qualified for Medicaid, one of the requirements was that Son could only have one real property. Well, Son and wife had their own home in Grand Rapids. So what happens to the cottage? Hopefully by now you've guessed the answer. But yes, because the cottage was owned by Son's separate share trust, the cottage was protected from being considered an asset of Son's for Medicaid qualification purposes.
Thanks, Heather. So again, Son's story is a very simple example, and there are many factors that come into play in getting qualified for Medicaid. However, I hope both of the examples we've discussed today with our son and daughter stories, however basic and simple they are, reinforces for you just what a powerful financial tool a separate share trust has the potential to be. So Heather, can you think of any other things we need to talk about with a separate share trust?
Yes, I'm wondering, can I add my own money to a separate share trust?
Good question. And the answer is no. A beneficiary cannot add their own money to their separate share trust. The separate share trust is only for their inheritance.
Okay, so what if I get another inheritance from someone else? Can I put that in this separate share trust?
Again, the short answer is no. The longer answer is that you might be able to create another separate share trust for this inheritance if the inheritance you are receiving is coming from a trust, and this trust provides that the beneficiary can receive their inheritance in a separate share trust. But this would be managed as a completely different separate share trust with its own tax ID number if this were the case.
I know I need to have a co-trustee on my separate share trust, but what happens if my co-trustee won't let me use my money?
Well, your co-trustee is somebody you picked as somebody that you trusted, so they should let you. But if for some reason the co-trustee would not cooperate with you and let you use your money, remember, it is your inheritance. The bottom line is you can fire them at any time and appoint a new co-trustee.
Good to know. I have one more question.
Okay.
Do I need to file a tax return for my separate share trust?
Well, we're not tax professionals, and we always tell people we know just enough about taxes to be dangerous. However, a separate share trust is a legal entity, just like a corporation is. So just like a corporation can make money, a separate share trust can make money too, in the form of interest earned or in the gains or appreciation of assets. So the best advice we can give you is that, yes, your separate share trust may have to file a trust income tax return. This would be an income tax return. So you should check annually, sometime in February, with your tax preparer to see that if you do need to file a trust tax return for your separate share trust. That way you don't have to worry about getting a letter from the IRS in a couple of years. But the key is you may have to file a tax return. It's not necessarily that you're going to always have to, but you want to check. And please do not let the prospect of having to file a trust income tax return prevent you from doing a separate share trust if it is available to you. Your tax preparer can easily handle this, and it is a small administrative price to pay for the protections afforded by a separate share trust. So this is how the separate share trust is generally managed. Heather, would you mind recapping for everybody?
Sure. So what we learned today is that a separate share trust allows a trust beneficiary to protect their inheritance in case of divorce, if they are sued in a lawsuit, or if they ever need to get qualified for Medicaid. A separate share trust is created by signing just a few documents. It is managed by the separate share trust beneficiary and their trusted co-trustee. And the separate share trust beneficiary and co-trustee have many options available to them for how they decide to use their money that's protected by the separate share trust. So at this point, I think we'd like to open it up to questions, if anybody has any that they would like to ask.
Brenda, do we have any questions?
What happens to the balance when the mother passes?
What happens to if there's any money left in hers,
Yes,
in her
when she
account?
passes.
So that is determined. There's a couple different scenarios that can happen. Mom and Dad's Protection Trust is going to provide a default rule. So if nothing happens in between or nothing, then Mom and Dad's Basic Trust will provide where that goes. So let's say Mom and Dad's Trust provides that once daughter passes away. Oh, okay, yes, I was asked to repeat the question. The question is, if daughter passes away and there's assets remaining in her separate share trust, what happens to those assets? So Mom and Dad's Protection Trust in this case would determine what happens to those assets. So it could say that if daughter passes away and there's remaining assets, it goes to brother, or it could go someplace else. But Mom and Dad's Trust also provides that daughter could use what's called a power of appointment. It's a fancy word. It gives daughter the right in her will. She'd have to have a will, and she could refer to this power of appointment, her right to change the distribution scheme. And so she could appoint the balance of her separate share trust assets to somebody else that she wanted them to go to.
Mm-hmm. Do you have any other questions coming through? No other questions. We'll give it a little bit more time, see if anybody thinks of anything.
We must have answered everybody's questions. I'm impressed. Maybe we could ask if any of our listeners, do they know, are they the beneficiaries of a separate share trust? Always respond in the chat feature. Okay, 67% of our listeners are beneficiaries of a trust. 67% of our listeners are beneficiaries of a trust. Well, if you don't know, then you might ask to see the trust documents if possible, and just see if you have this separate share trust option available to you.
Mhm.
All right, we have questions.
What if I don't want a separate shared trust? Can I take the cash?
Would you like to take that, Heather?
Sure. So the question was, what if I don't want the separate share trust? Can I just take the cash? Our trusts do allow for the option to either take the separate share trust or to take your cash outright. But it is important to remember that if you take your cash outright without the protections of a separate share trust, that could be affected by lawsuit, divorce, or if you ever need to be approved for Medicaid.
Next question. Have to have a separate.
The next question was, do you have to have a separate share trust? I think Heather answered that.
Yes, so kind of the same answer as before. No, you don't have to, but there are many benefits to choosing the separate share trust option when you receive your distribution.
The question is, do most trust documents have the separate share trust option, or is that unique to carrier law? I'm going to be honest, I don't know how other law firms do it. My guess is that it is unique to carrier law. That's just my best guess. Just because David Carrier is so knowledgeable and fluent in this area of the law. That would be my best guess, best answer.
In my experience, we have clients who come to us whose parents did have trusts that were established by other attorneys, and I have yet to see a trust from another attorney that provided for a separate share trust. So I'm not saying it's not impossible, I just haven't seen it.
Right.
Question. Can I add a separate shared trust to my existing trust?
The question was, can I add a separate share trust to my existing trusts? And I think the best way to answer that is just to make it clear that this would be a completely separate entity from any trust that you already have in place. So for instance, if you already have an estate plan with carrier law and you have a revocable trust and you have a protection trust, but you came into an inheritance that provided the option for a separate share trust, you would have a third trust that would be in addition to any additional estate planning that you have. And the difference with this trust is that all of the assets in that trust are automatically protected and only your inheritance can be held in this separate share trust.
And I think maybe another way to come at this too would be, let's say you have an existing trust and it was drafted, say, by another attorney, and you'd like to be able to add the option of a separate share trust for your children or whoever your trust beneficiaries are, then please make an appointment, come in with one of our state attorneys. They could review your existing document and we could redraft, restate, do whatever needed to be done to take your current trust and add that separate share trust option.
Mm-hmm.
Next question. Why won't trust have a separate shared trust option?
Why? The next question is, why would they not?
Yeah, why would one already not have that option?
Again, I think it's because it's something kind of unique to the area of law that we practice, which is really focused on Medicaid planning. And it's just something, again, that David Carrier is very knowledgeable and fluent about that maybe other attorneys don't specialize in as much. Again, that would be my best guess.
Yes.
Does the, if I add a separate shared trust and I get my inheritance, does that affect my current 5-year clock on my regular trust?
So the question was, if you come into an inheritance and you have the option to receive a separate share trust, the question was, does that affect the 5-year clock on my other assets? The answer to that is no. Any assets that are currently funded into your protection trust that the 5-year clock has started on, those are not affected by an additional separate share trust being set up. And again, any assets in that separate share trust are automatically protected. There's no 5-year clock for those.
All right, we've got any more questions out there? We'd love to hear from you. Give you about 10 seconds and then, yep. And then we'll say, all right, Well, thank you very much for attending today. We really appreciated it. Heather and I had a blast doing this, and we hope you learned something. And don't forget, it will be posted on our website that if you want to go back and just refresh yourself on part of this, it will be available soon. Thank you.